Right.
And also, I always wonder about this, about the substance of the agreement. So is it correct that if the agreement was way off what the law would provide, that would ultimately probably be set aside?
I think it's important to note that every court found that the financial disclosure was sufficient, meaning that these guys had a kitchen sink deal where they did look at their RRSPs, their bank accounts, and they said, okay, you know what? This is what you had a date of marriage. This is what I had a date of marriage. The increase was only about $10,000 that the wife had because it was only 3 years. So she gave him about half, which was 5. Right. Now, that's not what the law says. The law says that the husband was entitled to 50% of all her assets, not just what they each had a date of marriage. So I am sympathetic in this case because if they had gone by the law, the husband would have been entitled to about $85,000, which is what the trial judge had given him. So it was not a great financial deal for him because he didn't understand the law. But that's not enough. He made that decision going in. When they talked, he felt that that was fair. He felt that that $5,000 was fair and to keep his assets and her assets at date of marriage. And so that's why the financial disclosure is important. Here, in this case, in the Anderson case, there was financial disclosure. It just wasn't in the format that a lawyer would do it in. So lawyers have very specific court documents and a very specific way of outlining it. But the courts found that there was enough financial disclosure. So that's important. To your point about, would it have been unfair? I do think, and the case does say that they did not come to a very unfair arrangement, given the short duration of their marriage. Right. So that was a factor that the court considered significantly. They were only married for 3 years. So that increase in assets being $5,000, the court wasn't really upset about. I think if this was a 20-year relationship and one person gave $5,000 when they should have given maybe 90 or 190, maybe that could be a different circumstance, which is why I'm going back to saying this is a very fact-specific case where the chances of this applying to a lot of different families is low because of this family's unique circumstances.
So the takeaway then would not be couples can come to any kind of informal agreement and think that just based on Anderson and Anderson, they can just get away with it. I mean, ultimately, it's about fairness. If you end up going to court, the court's going to look at whether the contract is fair, there was meeting of the minds, and so on. And I wanted to ask you just one more question about fairness. As you know, there's always a subjective fairness, and then there's the fairness according to the law. So I'm imagining that if it comes to a court battle, the judge would look at whether a contract is fair based on what the law provides. That's
one element, right? Because the law here provided the husband with much more money, right? And so the Supreme Court still disregarded that. Right. But they looked at the other circumstances. They looked at the fact that there was no duress. The husband knew he could get legal advice and waived it. Right. That they knew each other's financials. They both the case also identified that they were both reasonably financially around the same playing field. So that was another piece. Whereas sometimes in mediation, for example, we will see families that have a big financial power imbalance.
Right.
Where that's a power balance, that goes back to Laura's point about covert duress. So, for example, if someone really wants to leave a home and they need spousal support to do it, and they make a bad deal because they have to leave the home in order to do it, that might not stand up in court because of the duress. Right? Which we can get into more of those examples if you like.